Someone make it make sense.
Probably a couple.
Hello, my friends. We are back here covering the latest out of Idaho, the state of Idaho versus Bryan C. Kohberger. We've got some documents here that were just filed just within the past couple days. Hot topics for today include IGG, and we also have an official response from the state to the defense as per the 5th motion to compel discovery. So we have a supplemental response there and a few other things as well. So let's jump right on in. So, in the District Court of the 2nd Judicial District of the State of Idaho, in and for the County of Latah, State of Idaho versus Bryan C. Kohberger. First, we have the Second Amended Order for Disclosure of IGG Information and Protection Order. This is an order from the judge. He's ordering, and we heard them discuss this in the hearing, but he's ordering that they turn this IGG information over. So, what is the IGG information? That is discovery, right? All right. Based on the May 30th, 2024 hearing, which we covered, I will include a link for that up here on the top right-hand corner of the screen and also in the description of this video. So based on the May 30th, 2024 hearing, the sealed order for disclosure of IGG Information and Protection Order is amended as follows. Defense Counsel, Ann Taylor, J. Logston, and Alyssa Masseth. Defendant, Bryan Kohberger. IGG experts, Dr. Leah Larkin, Becca Barlow, and Stephen Mercer, and defense investigators may view the IGG materials provided by the state. You guys, it's happening. They're going to get to see it. Any further dissemination of the materials or the information contained within the materials must first be approved by the court after a showing by the defense as to why such individual needs the information for the preparation of the defense. Additionally, no individual on the family tree who was not previously known to the defense via the defense's own investigation may be contacted by the defense or any agent of the defense without prior authorization from the court after a showing as to why such contact is necessary and material to the preparation of the defense. So basically, as far as the IGG materials go, they're going to turn all of that over to the defense. When it says here, like any further dissemination, that means if apart from these individuals that are listed above, if it's going to be disseminated beyond them to others, right, they just have to get approval first. And also here they're addressing the whole thing about the family tree because that was part of the issue. And we talked about that, right, because these are private citizens that don't need to have their information put on blast and whatnot. So, so they're saying you can't contact them unless you get permission and tell us why you need to contact them. The defense's mitigation expert who has created her own family tree and who does not have access to any of the IGG information may continue her mitigation investigation, including contacting defendant's immediate family members and other related individuals. So that's interesting. So when it says the defense's mitigation expert, remember that's what Ann Taylor, that's how Ann Taylor describes the sentencing phase. So, you know, because it's a death penalty case, right? And as we know, they have to prepare for these simultaneously. The guilt phase, which Ann Taylor calls the innocence phase, as well as the sentencing phase, which Ann Taylor calls the mitigation phase. So they're already preparing for all of that. So this, when it says mitigation expert, that is in preparation for if there's a guilty verdict. Now, it doesn't mean that she thinks he's going to be found guilty, right? This is required. Like, this has to be done, regardless of anything else. It has to be done because they will jump right into it, like we saw with Chad Daybell. Now, having said that, and I actually covered the most recent court filings for his case, and we talked about this a little bit in that video. I'll put a link for that as well up here in the right-hand corner and in the description of this video. But we did talk about some of the similarities and differences we can expect if Bryan Kohberger is found guilty and goes on to this next phase, that Chad waived a lot of his rights here in terms of mitigating like expert witnesses and stuff. So with Bryan Kohberger, what I think we can expect is them to jump right into that next phase immediately after the trial if he's found guilty, just like we saw with Chad Daybell. So in other words, that's why they need to be prepared, right? However, it will take longer. I will guarantee you that. And again, for more information, we did discuss that in further detail in that other video with the CHAD documents. But basically, they don't have a break in between. I believe, even with CHAD, it was like literally they just jumped right into it like the same day. So, and again, because it's the same state, we can expect some of the same court proceedings and the like. So the defense's mitigation expert who has created her own family tree and who does not have access to any of the So that is interesting that she does not have access to it. Interesting. Now she's allowed, and I'm saying she because it uses the pronoun her. She's allowed to continue her mitigation investigation, and she's also allowed there to contact the defendant's immediate family members and other related individuals. I do not remember hearing anything about this before. Now, it's entirely possible it came up in one of the bazillion hearings we've already had in this case any number of months ago. But I don't remember hearing anything about it recently. Now, and the other thing, too, is everything regarding the IGG has been really kind of locked down, right? So to my memory, this is new information about how they're handling it with this mitigation expert, and she's not being provided, it looks like, the same materials. So that is interesting. So this was ordered the 7th day of June, signed by Judge. All right, next up we have the state's third supplemental response to defendant's 5th motion to compel discovery. All right, so now we've got, this was filed by the state of Idaho. So state of Idaho versus Bryan C. Kohberger, of course, although here it says Christopher instead of C. All right, to the defendant and counsel, comes now the state of Idaho by and through the Latah County prosecuting attorney and submits the attached Exhibit 1 in response to defendant's 5th motion to compel discovery filed on April 15th, 2024. And we covered all that as well. So this discovery is in the form of an exhibit, Exhibit 1. So that's going to become important. So the state incorporates the following responses as fully set forth at this point. State's response to request for discovery filed on January 23rd, 2023. State's response to defense first supplement request, that's supposed to say supplemental, request for discovery filed on February 21st, 2023. State's response to defendant's second supplemental request for discovery filed on March 29th, 2023. Okay, I'm not going to read all these. There's a bunch. Holy shit. Yeah, look at all that. This is just a little taste, a little sampling of the bazillions of documents that have been filed in this case. All right, the last one. State's second supplemental response to defendant's 5th motion to compel discovery filed on May 28th, 2024, and we also have covered that. The state has and will continue to provide discovery in accordance with ICR 16 and applicable law. So ICR, that's Idaho Criminal Rule 16. And they've actually cited that quite a bit so far within the documents and within the hearings and stuff. So dated this 10th day of June, 2024, Ashley Jennings. All right, next up on the list. All right, what have we got here? Motion to temporarily seal Exhibit 1 of state's third supplemental response to defendant's 5th motion to compel discovery pending hearing. That's a mouthful, isn't it? Okay, so basically, the moving party here is the state. Why? Because it says come now. They left off the S. Comes now the state of Idaho. That's the moving party. So this is the state's motion, they're moving, to temporarily seal Exhibit 1. Now this is a mouthful because remember, when I said Exhibit 1 would come up again, bam, that was from this. Let's go back and take a look here. So see this Exhibit 1? Like in case anyone got excited like we were going to see Exhibit 1, nope. So a motion to temporarily seal Exhibit 1 of this document, which we just read, pending hearing. That's all we need to know. So this document is the biggest chunk of this mouthful here. Come now the state of Idaho by and through the Latah County prosecuting attorney and hereby moves the court pursuant to, there's our ICAR again, Idaho Court Administrative Rule 32G. We've heard a lot about that one. And Idaho Code 74-124 for a temporary order sealing Exhibit 1 of the state's third supplemental response to defendant's 5th motion to compel discovery herein because release or disclosure would. And if anyone who's been following these documents with me is very well familiar with these same exact rules here because they've cited this so many times. I feel like I have this portion of ICAR Rule 32G memorized. All right, 1, interfere with enforcement proceedings. 2, deprive a person of a right to a fair trial or an impartial adjudication. It's kind of a tradition now that every time when I read that one, I comment on the fact that it's almost like they're trying to usurp his 6th Amendment right, which is a bit weird. And just like last time, look at this. 122. Or was that in one of the Chad documents? Or maybe both. There was one recent, I feel like it was maybe both. Maybe there's like a template that they have in Idaho that has these numbers and they're all using it and like nobody's fixed it. I don't know. But this just happened in a recent document. I believe it was Chad. And I think it also happened recently with something with Kohberger. Anyway, it was the same thing. It was supposed to be a 3 and it was another 2. Crazy. All right, I'm going to fix it for them. Number 3, constitute an unwarranted invasion of personal privacy. 4, disclose the identity of a confidential source. And or 5, disclose investigative techniques and procedures. Again, these are the same ones we've seen before. The undersigned seek this protection pending a hearing on the matter, right? So that means there's going to be, guess what? Another hearing. Wherefore, the state respectfully prays that the court seal from public disclosure Exhibit 1 of the state's third supplemental response to defense fifth motion to compel discovery herein under the provisions of ICAR 32G and Idaho Code 74-124, and Taylor has confirmed that the defense does not have an objection to this motion respectfully submitted on the 10th. Again, another document there on the 10th. Let's see what happens, because what we know is right now the state's been praying, right? Let's see what happens. Will judge come through for them or not? Let's see. All right. Last for today, temporary order sealing Exhibit 1 of the state's third supplemental response. Again, a mouthful, but we already know from the previous document that they're going to have a hearing about it, right? So again, that was their motion to temporarily seal the exhibit, and he's ordering it be sealed temporarily, right? And again, this big mouthful is just this document here that we already covered. Temporary order sealing Exhibit 1 of the state's, this document, right? Pending hearing. So, based upon the state's motion to temporarily seal Exhibit 1 of the state's third supplemental response to defendant's fifth motion to compel discovery pending hearing, filed herein, and no objection from the defense, the court does hereby confirm and order that Exhibit 1 of the state's third supplemental response to defendant's fifth motion to compel is exempt from disclosure and sealed pursuant to Idaho Court Administrative Rule ICAR 32G for the reasons stated in the said motion and until a hearing can be held on the matter. So they have not scheduled a hearing yet. What they'll probably do is schedule a hearing to schedule the hearing, because that's what we've seen them do so many times. And again, this was also filed on June 10th. So you might be asking yourself, if they are just going to seal this exhibit, why even bother? Like, what is the point of, this? So also what I will say is, because there's a logic to these things, right? So let's just review. The first thing we had here was, guess what? The IGG, turning over the IGG stuff, right? That's discovery. And sometimes when discovery is provided, the public gets to see it, and other times it doesn't, right? So in this case, the discovery is this IGG information, right? So the first step is judge orders it being turned over. The second step is the state provides it. So they are complying, they're turning over the discovery, which would include Exhibit 1, right? There it is, Exhibit 1. And then we have the motion to temporarily seal it pending a hearing, and an order to temporarily seal it pending a hearing. So you might say to yourself, why then bother with all this? Well, it's important because it shows that they complied, right? In other words, it's for full transparency, so we know what's going on. And at some point pending this hearing, that exhibit may not be sealed anymore, right? It's temporary. And this is true for anything else in this case or other cases, right? And then at that point, it'll become attached to this document. And this will have already been in place, right? So then it will make sense. Like this is because whether or not, like in other words, these motions to seal it and orders to seal it are separate documents. So this document will remain unchanged. It's just the difference is that the attached exhibit, which look, there it is. That's where it would go. Look, under seal with court, Exhibit 1. So if it's ever not under seal, this will be replaced with Exhibit 1, right? But the rest of this will be exactly the same. So hopefully that makes sense. So yeah, so that's the latest out of Idaho. So the next thing we'll hear, I guess, will be about scheduling the hearing for this matter with the IGG discovery. We know that there's another hearing scheduled to review the change of venue type of stuff, and that was pushed back because of what's his face, the expert who's doing the surveying people for a jury. That was pushed back to August. But hopefully you guys enjoy being kept up to date on this stuff. Let me know if y'all have any questions by leaving a comment. And I do have a playlist as well for everything that I've done so far with this case, and I will have that linked in the description as well as up here for you guys in the right-hand corner of the screen. And until next time, thanks for watching and thanks for being a squirrel, and we'll see you on the next video.